Sometimes immigrants who are in the United States who have been married to a citizen or a resident are victims of domestic violence or psychological mistreatment and think that they can't now become a permanent resident because the relationship to their U.S. citizen or legal permanent resident spouse has been damaged. In these circumstances, the person can file what's called a self-petition. It's interesting because usually in these circumstances, the U.S. citizen spouse or permanent resident spouse who has been psychologically or physically violent towards their immigrant spouse has often used the immigration status as a point of leverage and has tried to make the immigrant feel like the U.S. citizen or permanent resident spouse has control over them because of the immigration situation. And this is just not the case. USCIS is the body that approves or denies residency in this country, not the U.S. citizen or legal permanent resident spouse. But oftentimes they try to use that in the arguments that happen during the marriage, right? So if the person is separated or has even been divorced but for less than 2 years, or maybe in some cases even still living with the person who has been violent towards them, they can file a self-petition. So they would file what's called an I-360 to a service center that's specially dedicated to approving or denying these cases, and the process is known as VAWA. And that means or stands for Violence Against Women's Act. It's not only a violence against women, it can be violence against men as well, but that's the name that Congress has given this particular procedure. So what happens is the intending immigrant will file an I-360 with evidence that the person has been a victim of some type of abuse, but also evidence that the original marriage at the very beginning was a legitimate marriage. They married this person not for the purposes of getting papers in the United States, but also because they really loved the person, they really wanted to make it work, right? So they'll file that type of evidence. They also need evidence that that spouse was a permanent resident or a citizen, which is hard to get if there's already been a separation. Now you've got to go back to somebody who's abusing you and ask them for documentation. Very hard to get, so it's something to think about beforehand. So they need evidence it was a valid marriage, evidence of the immigration status, citizen or resident of the abusing spouse, and then also evidence that that was a valid marriage at the beginning. They can file this application, also an I-485, which is an application for residency. And then this application is approved in two different parts of a process. This specialized office approves the I-360 at one location and then sends the I-485, the application for residency, to a more local office in the city or state closest to the applicant to approve the actual residency part of it. So because it's approved in two different places, sometimes it takes a long time. It can be 2.5 to 3 years depending on the backlog of the USCIS offices. In the meantime, the immigrant can also be approved for a work authorization so they can work validly in the country while they're waiting for these applications to be approved by a USCIS officer. Sometimes the local office will try to sort of rehash or reopen the domestic violence part of the thing, but they can only determine if it's already been approved. The local office can only determine whether residency should be approved or not. So sometimes there's not even an interview in these cases. Oftentimes they're approved without an interview, but it kind of depends on the amount of information that we've sent in with the application in the first place. We're going to leave some links in the description below and some description of the links so that you can get some more information about this process known as Violence Against Women's Act and how an immigrant in the United States can become a resident even if they have left a marriage, but where they've been a victim of some type of violence, psychological violence, domestic violence in that relationship. Also, you can contact us to help you out with this type of case. We've been doing these types of cases for years. We have several clients who are now in the United States with a residency card and even in line to petition for their citizenship in this country. And they started out hopeless. They felt like their U.S. citizen or permanent resident spouse who kicked them out of the house had complete control over them. And then they realized that no, that they still had a pathway to become a resident in this country.